Okay, let the record reflect that the defendant is present along with counsel for the defendant. Assistant State Attorneys. Okay, are there any preliminary matters we need to bring up? Okay, Mr. Ashton.
Good morning.
Morning.
I would like to address the discovery issues as to the Mr. Richard Eichenblum, who was addressed briefly yesterday. We completed his deposition yesterday afternoon. I provided the court with a copy of that, a very rough copy that we received by email. Today, I believe that counsel has received it as well. Upon review of the case of McDuffie versus State, found at 970 Southern 2nd 312 at the court's suggestion. At this point, Your Honor, we believe that a discovery violation clearly has occurred. We do, however, believe that exclusion of the witness outright is not necessary, and we would not be requesting that the witness be prohibited from testifying. We don't believe that that would be in the best interest of the defendant or in the future of this case. We would, however, request that sanctions be imposed in the following way. The court has already addressed that it will, in all likelihood, address contempt issues at the close of the trial, and we would suggest that this is an appropriate matter to be included within that. We have, in the deposition, we have been able to overcome procedural prejudice in most aspects of his testimony, and I believe that I will be able to cross-examine him effectively. The only area that I cannot is one particular opinion of the witness. The witness proposes to provide an opinion which is based on the scientific principle that DNA is recoverable from decomposition fluid. This is discussed in the witness's deposition starting at page 51 going through page 62. This is an issue which, had it been properly provided, would have been the subject of a pretrial Frye hearing. The witness in his own deposition acknowledges that that scientific principle is not based upon any peer-reviewed research. It is not based upon any research at all. He would accept that principle based simply on some anecdotal experience of his own. Obviously, at this point, the state is, because of the late discovery, and I will comment that the deposition also reflects that the opinions that this expert has formulated were formulated on Saturday, that he was never informed of the court's order about preparing a report containing all the opinions, and that he basically indicated in the deposition that he flew over here on Wednesday and didn't formulate the opinions till lunch on Saturday. So what we would request, number one, is that that portion of the witness's testimony in which he would give opinions about the lack of DNA results from the carpet stain be excluded because of the procedural prejudice that the state is deprived of the opportunity to have a full and fair Frye hearing. There is substantial indication in the deposition that the information would not survive a Frye hearing, that the proponent, being the defendant, could not establish the general acceptance of that principle. And under I think the most similar holding is actually the Cybers case, which the defense has argued at length in Frye hearings at 841 Southern 2nd 532, which basically, again, as the court is well aware, stood for the proposition that if a scientific principle is based in Cybers on the ability to obtain a certain chemical from a embalmed body was not scientifically accepted, and the opinion could not be offered. And again, obviously we can't have a full Frye hearing, we don't have time, but I would request that that specific opinion be excluded as a sanction of discovery. Again, to remind the court, and I'm sure the court remembers, the defense has already had one witness testify about this issue. Ms. Subert from the FBI was allowed to testify about the effects of decomposition on various fluids and whether you might or might not be able to get DNA So they have offered that testimony already. So I would object to this new expert giving an opinion based on a non-accepted scientific principle. Aside from that, we will be able to address in cross-examination the remainder of his testimony. We would request, though, an appropriate instruction to the court at the time the witness testifies. I've handwritten a suggestion, which I'll read into the record, and if the court wants to have it, if you can read my writing, I'll hand it to you, which would say, in essence, all reports of experts were required to be provided well before the beginning of this trial. The report of Richard Eichenblum was not provided to the state until Sunday, June 9th. I'm sorry. Until Sunday, June 19th, 2011. You may consider this fact in judging the credibility of the witness's testimony, and in determining what weight it should be given in your deliberations. We feel that that is a fair, balanced approach to the discovery violation, and the issue of contempt would be left for another day. Thank you.
What says the defense?
Good morning, sir.
Good morning.
I filed a response with the court on December 15th of 2010, where Mr. Eichenblum where the court had asked that I explain what he may be called to testify. And I listed his CV, Mr. Eichenblum's CV, field of expertise, as being DNA, crime scene analysis, and trace recovery. On sentence 3, I informed the court and the prosecution that if Mr. Eichenblum were called to testify, he would testify in the areas of DNA, crime scene analysis, and trace recovery. Sentence 4, he's reviewed all reports and photographs taken at the recovery site and personally inspected many of these items, and that was during the evidence inspection. Number 5, if Mr. Eichenblum were called to testify, the substantive facts that he would be expected to testify would be to rebut any false claims raised by the state's forensic experts dealing with DNA, crime scene analysis, or trace recovery. Until that occurs, it is difficult to give a complete summary of his opinions and the grounds for those opinions. I raise that because this is a very complex case, especially forensically. What I would like Mr. Eichenblum to testify to would be the issues raised about degradation of DNA. And I think this notice should be sufficient to put the state on notice that that's an issue that he will be testifying to. The opinions, this is completely separate than the issue we had with Dr. Rodriguez, and I'd ask that the court consider it differently, and I submit this for your honor's consideration. As these issues came up, and we knew that we wanted to, and when your honor gave me the example of his own personal experiences, I wanted to take that benefit, the benefit of that knowledge, and apply it in this case. I'm sure, as Mr. Ashton had mentioned, these opinions were formulated on that Saturday because these were issues that I asked him at that time. I knew we were going to take depositions, and I thought of taking full advantage of the fact that we were going to take depositions and perhaps be able to expand issues that he may be called to testify to. It's not to create any gotcha moments or anything like that. So what I would suggest to resolve this entire situation as it relates to Mr. Eichenblum would be to call Mr. Eichenblum to testify solely to those issues of DNA having to deal with degradation. While I would love to argue about the whole point of exclusion that Mr. Ashton had brought up the issue about the being able to collect samples from decomposition fluid. Ms. Subert testified to that, and no objection was raised by the state, and they never asked for a Frye hearing then. But yet, as Mr. Eichenboom testifies, in order to try and inflame the court into thinking that sanctions are warranted here, he creates this ruse of an issue saying that we need a Frye hearing and we've got all these problems and all these issues, when the fact of the matter is it's not so. So in efforts to move things along, I would propose to the court, and I don't know if this is acceptable to Mr. Ashton, but he certainly has had plenty of notice of which, and that is to solely limit Dr. Eichenboom's testimony as to explaining DNA, specifically low copy number DNA, which Ms. Subert, unfortunately, the FBI doesn't do that type of DNA, and this witness is uniquely qualified for that, which of course the state knows, and explain issues of degradation. Generally speaking, I could give him hypotheticals as it relates to some of the issues in this case, and then we can move on with this trial. I know Mr. Mason will address some other issues dealing with the other witness, but I just kind of wanted to propose that to the court and see if we can resolve this issue and just move forward.
Thank you.
Brief response, Your Honor?
Yes.
Just very briefly, just to point out that the state did not offer any DNA evidence in this case. The DNA evidence was offered by the defense, so the defense is, in a sense, rebutting their own witness in that sense. The other is, I'm not sure I understand counsel's proposal. If his proposal is that the witness will not give an opinion about the ability to get DNA from decomp fluid, then that's acceptable to me, as long as he's not going to make any opinions about the carpet sample. Then I don't have a problem. That was the only area where I felt that there was procedural prejudice. So if that's counsel's intention, then that resolves that issue. I do not believe, however, that the instruction, I think, would still be necessary, and I believe the other proceedings later in the trial would also still be necessary. But as far as the witness goes, if that's what he means, that's fine.
Let me ask both sides to address this. At some point, the court granted the defense's motion to have certain items of evidence at taxpayers' expense tested for DNA, and it was sent somewhere, I believe, up north, correct?
Yes, sir. National Medical Services Laboratory in, I think, New Hampshire.
Okay.
Pennsylvania, excuse me.
And what items were tested?
I believe that the shorts and the bag were tested. I don't believe that the tape, I'm sure, was not tested, but I'll refer to counsel if anything more than that. I think it was just the victim's shorts she was wearing and the bag that she was found in. That was it, as far as I know.
What happened to the tape and what happened to the carpet samples?
The defense never requested that those be tested, to my knowledge, as I recall the motions filed.
Okay. And he's proposing to testify about the possibility of DNA on duct tape.
Yes, sir.
And he wants to testify about carpet and the ability to test carpet for decomp fluid to extract DNA from that.
That is correct. According to the deposition, the witness was not aware of which items were requested for DNA testing or what the results were. He apparently was never informed of which items were being requested or what the results were, according to his deposition.
So in other words, he was not aware that those items could have been tested for DNA and they were not.
I believe he would say in his deposition that he believes they could have been tested, but was unaware that they were not.
Okay.
May I address those?
Yes, sir.
With the court? We're talking about completely different types of DNA testing. The testing that he does is low copy number DNA type testing. They utilize a special kit called the mini filer that allows you to get DNA from very, very, very minute amounts. That type of testing is unique. We requested that they be allowed to test items, and that, of course, was objected to by the state, and the state granted or sustained their objection and denied our opportunity to have him test these items due to a very specialized subfield of DNA that he is one of the pioneers of. In the alternative, we were granted the ability to test certain items by an ASCLD certified lab. We asked specifically for a different type of DNA for those items because we thought it would probably be the most likely scenario for us to be able to accomplish getting something of benefit to the defense. And that type of DNA was not low copy number DNA, it was YSTR DNA.
So are you saying that there's no certified lab in the continental boundaries of the United States that does low copy DNA testing?
My understanding is that the only crime lab currently doing low copy number DNA is the New York City Crime Lab. And I am not aware of any other ASCLD certified labs that do low copy number DNA in the United States. In Europe, it's quite prevalent. Of course, DNA was actually discovered in Europe and developed in Europe, and they're, by many people's estimations, a little bit more advanced than we are here in the United States as far as low copy number DNA is concerned.
And has low copy DNA been fry approved yet?
It has. Well, let me rephrase that. It has been used in cases throughout the United States, but whether it's been fry tested here in Florida, I can't say.
According to the witness's deposition, the procedure he uses is a standard procedure developed in other laboratories. He did not indicate that he does any. He explained that low copy number is simply additional replicating runs of a traditional PCR method. Instead of running it 24 times, you run it 30 times. He did not indicate in his deposition that this is a procedure which is unique to his laboratory. He did not indicate in his deposition that this is not done in the United States. And I'm not aware of what counsel is referencing about the inability of United States laboratories to perform these DNA tests. This is the first that I've heard of that, so for what it's worth.
That's absolutely not true. There's a special kit called the mini filer. I'm certain Mr. Ashton's aware of it. It's not just doing extra runs in the PCR process. It is a specially designed kit, and it is, how prevalent it is in the United States, it's still up and coming. From my understanding and my studies of DNA, I can represent that to you, and I can say this much. I have studied quite a bit in this area, and Mr. Eichenboom is well known throughout the DNA community as being a pioneer in this area. Whether he does something a little bit different, other than the amplification process and using these specialized kits, and more importantly, the type of trace recovery that they utilize. And the witnesses here, you can testify as to the uniqueness of what it is that he does that's different, but we would have certainly object to any, especially since we are conceding and willing to stick to areas that are and should have been very well known to the state to anticipate Mr. Eichenboom's testimony, for which they did not take his deposition up until recently. We would object to any specialized instruction trying to punish the defense in any way other than what we've just discussed.
Okay, anything else?
Nothing further, sir.
Okay. The court hearing arguments of both the state and the defense will grant the state's request for the instruction and at this time would prohibit the testimony concerning the possibility of testing by DNA analysis of the decomposition fluid in the trunk. Now, what the court would do out of abundance of caution, if since it looks like we're going to be doing this for the next 2 weeks, if you want to schedule a Fry hearing, giving the state at least 1 week's notice, I will consider doing that to see whether or not it would be admissible. But for the time being, it is not going to be permitted as a sanction for not disclosing it. But I will not permanently shut the door, but give you an opportunity upon proper notice. I will permit anyone that has an expert to testify by video conferencing if you want to conduct a Fry hearing. Okay. Yeah. Hope I can read your writing.
Your Honor, we would object to the state's. We hadn't been given a copy of the proposed instruction. I just looked at it now.
You have an alternative instruction?
We didn't know they were going to be requesting one. We can prepare one.
Who's going to be your first witness this morning?
We can, to delay the issue, call Dr. Jane Bach, and in the meantime, we can prepare. Hold on, I'm getting lip read. I believe we can call other witnesses to, in the meantime, while we prepare instruction.
Okay, prepare one, have someone kind of give it to the court deputy, give to me, and then between the two of them, I will fashion something on my own.
Yes, sir.
Okay? Anything else, folks? All right, let's return to jury. Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? Okay, does the state recognize the presence of the jury? And does the defense? The defense may call their next witness.
The defense will call Jennifer Welch. Please stand, raise your right hand, and answer out loud.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah. Please start, please.
My name is Jennifer Welch, W-E-L-C-H.
You may proceed.
Thank you. Ms. Welch, I believe you've already established that you are a CSI Orange County crime scene investigator. Is that correct?
Yes, that's correct.
Okay. All right. And did you author a report dated February the 1st, 2009, and the bait stamp would be 3433?
I don't have one with that date on it.
Do you have a report that indicates the end-of-day observations with regard to clearing of the scene December the 12th through the 14th?
Yes.
Okay. All right. Can you explain, or if you need to refer to your notes, that's fine, what your observations were?
Yes. Yes, on that day, December 14th, 2008, at the end of the day, I made observations that during the period of December 12th through December 14th, with December 12th being the first day of searching and clearing the scene, that the areas had been cleared of leaf litter and vegetation from approximately 0 to 4 inches, and around the trees and the tree roots where the crevices were, it had been cleared approximately 0 to 10 inches.
All right. And do you have an end of scene, a day scene observation, bait stamped 3433?
I don't have,
It says page 22 on the bottom.
thank you.
There's handwritten bait stamps, so ours may be different.
Yes, page 22 of my report is what I just
Okay.
testified
All right.
about.
And did you read the last sentence?
The last sentence under my end of day observations?
Yeah.
Yes, that's what I had mentioned about around the tree and tree roots being cleared approximately 0 to 10 inches as determined with the tape measure.
Okay. Now, I believe you previously testified that you took photographs when you arrived at the scene. Is that correct?
Yes, that's correct.
Okay. And when you took photographs in and around the area of the scene in which the remains were moved, did you alter the remains or take anything off the remains that was touching the remains or the vegetation around it, other than to maybe lift something that was hanging over it?
The vegetation around the area was cleared to the point of the vines being cut and tied back, but I do not recall removing any vegetation from actually on top of the skull or on top of any other evidence, again, other than just clearing away vines that was obstructing the view.
All right, and I just need to confirm in terms of the photographs that you took, they would be CSI call numbers. Is that correct? Is that how you determined them?
The photographs are entered into our database under call ID numbers. That's correct.
All right. And are you familiar with the call ID number 1932?
I do not have a record of 1932 as a call ID number.
All right. Did you take photographs of the scene after the vegetation had been cleared?
Yes, I did.
Okay. All right. May I have permission to publish this just to the witness?
Which exhibit is it?
This has not been entered in yet as an exhibit.
Okay. You may publish it to the witness.
Request that it be marked for identification so that there is a permanent record of what's being shown.
What would that number be?
Hand it to the clerk. Yes. Speak up a little louder so the clerk can, the court reporter can hear you.
It appears to be, yes.
That appeared to be a photograph
Okay.
that represented the scene after the vegetation had been cleared.
Thank you.
And I'm not really sure how to work this, so, Will, can you?
It's upside down. Flip it over, yeah.
There we go.
Pull it down, son.
See these fitted between these
Ah, I see. Okay, great.
Published to the witness, not to the jury.
You're on permission to publish to the witness?
You offered in the evidence?
Yes, sir.
Any objections from the state?
No, sir.
It will be received in evidence as defense exhibit number. Okay, you may publish it to the jury.
Thank you. And can you identify, please, what that photo?
Okay, it's up. It's about a 4-second delay.
That's right, I forgot. Ms. Welch, can you identify that photograph, please, and advise the ladies and gentlemen of the jury what that represents?
It appears to be the scene after vegetation had been cleared.
Okay. And is that an accurate depiction, in your opinion, of the scene, the area in which the remains were found after the vegetation had been removed?
From what I recall, yes.
Okay. Permission to unpublish, Your Honor?
You may.
Can you tell me, please, in your report, and since our Bates stamp pages appear to be different, if you could look on page 5 of your report, and can you tell me, please, whether or not there's a reference to a log or a tree near the remains and what happened to that log or tree?
Yes. The log was located directly near the skull, which was observed on December 11th, 2008. During the process of clearing and moving vegetation, the log was moved by Chief Medical Legal Investigator Stephen Hansen and my supervisor Susan Mears on scene.
I have a photograph that I would like to, with the court's permission, publish to the witness for identification. And it's 1840-196206.
Okay, has the clerk marked it?
Yes, sir.
Okay, let the clerk mark it.
Thank you. Do you recognize that photograph?
Yes.
Okay. And is that photograph an accurate and true depiction of the scene in which the remains were found on December 11th, 2008?
Yes.
Okay. Your Honor, may I have permission to publish this to the jury?
Any objections? Did being offered into evidence?
The only objection is as far as time when it was taken and what point. I would object to the relevance unless we know at what point in the process this photo was taken.
I'll be glad to clarify that. Can you tell us approximately when this photograph was taken?
I cannot give you an approximate time, but I can tell you that from looking at this photo, this appears to be a photo that I had taken after vegetation had been moved out of the way. In other words, to aid in no longer obstructing the view.
When you say
Go ahead, ma'am. Go ahead.
when you say after vegetation had been moved away, that's hanging vegetation, not anything that's laying on the items themselves. In other words, no leaves were removed or twines that were actually touching the items. Is that correct?
Yes, from what I recall, this photo is just vegetation being moved out of the way to no longer obstruct the view. I do not recall removing vegetation off of the items.
Okay. Your Honor, may I have permission to publish to the jury?
Okay, any objections to coming in evidence?
No, sir, no objection.
Madam Clerk, be admitted into evidence as defense exhibit numbered.
A will become defense exhibit number 28.
Okay, you may publish 28.
Can't tell if it's up. Okay. Thank you. Your Honor, may I unpublish?
Members of the jury, have you seen it? Okay, you may unpublish.
Thank you. That's all I have of this witness, Your Honor.
Cross-examination.
This one? Mhm.
May I republish Defendant's Exhibit 27, Your Honor?
You may.
To the jury. Just, can you tell us what portion of the scene, this is, maybe orienting us by some object that was found? I'll zoom out a little bit so we can see the whole thing, if that helps you.
While it does appear to be a photograph of the scene, without going through my CD of photos in the sequence of photos, I can't tell you precisely where in the scene this is located.
So you couldn't point to a spot and say, well, this is where the skull was, this is where the back. You don't know from this photograph.
That's correct.
No further questions, Judge.
Any redirect?
Just very briefly. Ms. Welch, how did you identify the grouping of photographs? Did they have call numbers? How did you do that?
I guess I don't understand the question. I'm sorry.
Okay, you took photographs, and there's a series of photographs that I understand it have CSI call numbers like 1832, which contains a number of photographs, 1840, 1842. What was your identification system for those photographs?
What I did was I took the photographs out on scene, and then they were uploaded into our digital crime scene system. When they are uploaded into that system, the system gives it a call ID number. That way we can go back into the system, or a detective, if needed, can go into the system, put in that call ID number, and pull up the photos that are under that call ID number. So it is not a number that I created, it's a number that the system created.
Okay, and do you have those numbers here today?
Yes, I have the numbers.
Okay. And just for clarification, if I read them to you, would you be able to verify that they are, in fact, the CSI call numbers for the photographs that were taken on December 11th, 2008?
I would be able to tell the number of photographs without actually going through my report and looking at the corresponding number of photographs to the call ID. I wouldn't be able to tell you exactly what day the call ID matched up with.
But you would be able to determine that these were photographs that were taken at some point in time, December 11th through the 14th, approximately?
December 11th through the end of the investigation, I would, yes.
All right. And do you have those call numbers readily available?
Yes, I do.
Okay. Would one be 1838?
I do not have a call ID number of 1838.
Okay. What are the call numbers that you have?
I have call ID numbers 1840, 1842, 1845, 1849, 1893, 1903, 1913, 1919, 1923, 1934, and 2088.
All right. Thank you, Your Honor. That's all I have.
Okay. Any additional questions? No, sir. May Ms. Welch be excused? Okay.
Yes, sir. Again.
You may be excused, subject to recall. Thank you, Ms. Welch.
Thank you.
Defense may call their next witness.
Your Honor, the defense would call Dr. Jane Bach.
Okay.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please. My name is Jane Bach, B-O-C-K.
You may proceed.
Thank you, Your Honor. Dr. Bach, what is your occupation?
I'm a botanist.
All right. And what type of botanist are you?
My specialties are plant ecology, plant anatomy, and forensic botany.
And can you tell us what forensic botany is?
Forensic botany is the applications of plant science to matters of the law.
All right. And can you give us the benefit of your education?
Certainly. I have a bachelor's degree in botany from Duke University in North Carolina, a master's degree in botany from the University of Indiana in Bloomington, and a PhD in botany from the University of California at Berkeley.
All right. And have you had an occasion to teach botany?
Yes, I'm a retired biology professor, and I taught botany for, and I'm still teaching it a little bit, 40 years.
Can you speak a little closer to the microphone? I think some people may be having problems hearing you.
Yes.
Can you say that again? You taught what?
I've taught botany for 30 or 40 years.
All right. And have you authored any publications in scientific peer-reviewed journals on botany and forensic botanical issues?
Yes, I have about 80 peer-reviewed papers, maybe slightly more by now.
And what does peer review mean?
It means that you send in a manuscript to an head editor, and if they decide it might be of interest to their readers, they send it out to people thought to be expert in the field of the topic of the paper.
Okay, and have you authored any books?
Yes, I've authored 3 books and edited another one.
And what are the topics of those books?
Two are on plant ecology. One is on forensic biology and botany. And the third one is on plant ecology
Plant ecology?
edited. That I edited.
All right. And can you tell me, please, whether or not you've received research support and from what organizations?
During my academic career of about 30 years, I had continuous research support from the National Science Foundation, not all of them at the same time. The National Science Foundation, the National Institutes of Justice, the Charles A. Lindbergh Foundation, the National Park Service, U.S. Forest Service. That's a good sample.
All righty. And what organizations, what professional organizations are you a member in?
I belong to the American Academy of Forensic Sciences. I belong to the International Association of Identification. I belong to the Botanical Society of America, the British Ecological Society, Neck Research International, and a couple others.
All right, and can you tell me whether or not you've given testimony in trial or deposition as an expert in forensic botany?
Yes, I have.
And approximately how many times?
50 plus if you count depositions.
And have you ever given testimony in cases in which you applied your knowledge as a forensic botanist to determine whether or not the remains of an individual had been moved from one location to another?
Yes.
Your Honor, at this time we would like to offer Dr. Bach as an expert in botany and forensic botany.
What says the state?
No objection to her qualification, and if I may have a moment with counsel as the court is announcing her.
Okay. Ladies and gentlemen of the jury, Dr. Bach would be accepted as an expert witness in the area of forensic botany and permitted to render opinions in that area. You may continue.
Thank you, Your Honor. Dr. Bach, what items have you reviewed in preparation for your testimony here today?
I have looked at photographs taken by the medical examiner and photographs taken by the Sheriff's Department crime scene investigation people. And I have visited the discovery scene, and I have read several documents, printed documents concerning the case.
All right, what printed documents have you reviewed?
I've reviewed the medical examiner's report. I've reviewed the description of the recovery site as described in Ms. Welsh's materials.
All right, and any reports from anyone else?
Yes, I've read the report of a forensic botanist, David Hall.
All right, at some point in time, Dr. Bach, did you visit the area in which the remains of Kaylee Marie Anthony were found?
Yes.
And when was that?
That was the first day of February.
Of what year?
2009.
All right. And can you tell me, please, whether or not you took any photographs?
I didn't take the photographs, but with me was Patrick McKenna, a photographer, and he took photographs of me at the crime scene and of the, not crime scene, excuse me, recovery site and my work there.
Your Honor, may I have permission to show the witness an enlarged photograph that was taken at the time in which she was visiting the scene?
You may.
Are you familiar
Yes, I am.
All right. And how are you familiar with this photograph?
This is one of the pictures that Patrick McKenna took when I was at the recovery scene.
And can you tell me whether or not it accurately reflects your visit on February the 1st, 2009 to the area in which the remains were found?
Yes, it does.
Your Honor, may I have permission to publish the jury?
Have we got an ID number on it?
Oh, I'm sorry. Oh, it is. Okay.
If it's being moved into evidence, I have no objection.
It is 2008. Oh, CE. I apologize. It's CE.
You offered it in evidence?
Yes, sir, I am.
What says the state? Any objections?
No, sir.
It be received in evidence as defense exhibit number.
Number 29.
You may publish.
Thank you, Your Honor.
I might want to suggest we might want to get a lavalier mic for Ms. Sims. She's very soft-spoken. I'm not sure that people are going to be able to hear her without.
Yes.
I can be louder.
Okay.
Well, it's a lot easier with a lavalier mic, so.
Okay, yes. Dr. Bach, can you describe what is here, this area on the ground? What would you call this?
I'd call that leaf litter.
All right. Thank you. Your Honor, may I have permission to move the photograph down? Yes. Thank you. Can you tell the ladies and gentlemen of the jury what leaf litter is?
It's a general term used for leaves that fall off vegetation overarching the area where the litter accumulates. Mostly, in this case, it was leaves, but also pieces of stems can fall off of trees and needles from evergreen plants.
All right. Dr. Bach, let me ask you, after having read the reports and the photographs that you mentioned and having visited the scene, the area, some 7 weeks and 1 day later, can you tell me whether or not you have formed an opinion as to the shortest period of time that the remains of Kaylee Marie Anthony could have been at the scene in which they were found?
Yes, 2 weeks, approximately 2 weeks.
And can you tell us when the remains were placed there?
No.
And what is the basis for your opinion that it is possible that they were placed there approximately 2 weeks prior to their discovery?
Because of the pattern of the leaf litter.
The pattern of the leaf litter?
Yes.
And with regard to the vegetation that was found in the car that was driven by Casey Marie Anthony, do you have an opinion with regard to the vegetation that was found in that car versus the vegetation at the scene?
It isn't in agreement with the vegetation.
I don't believe it's been established that the witness has ever looked at the vegetation.
That the witness has ever looked at the vegetation from the car, or what her basis of knowledge of that is.
I'll back up and clarify.
Sustain, establish your foundation.
Dr. Bach, did you review a report from Dr. David Hall dated October 31st, 2008?
I did.
Okay. And can you tell me whether or not Dr. Hall set forth items that were found in or under the vehicle driven by Ms. Anthony?
He described vegetation and vegetation fragments associated with the vehicle.
All right. And with regard to that vegetation, what kind of vegetation was found?
Bits of leaves, for the most part.
From what?
Especially from a camphor tree.
All right. And can you tell me, please, whether or not there is a camphor tree at the scene in which the remains of Kaylee Marie Anthony were found?
There is not one.
Did you review a report authored by Dr. Hall dated February the 9th, 2009?
Yes.
All right. Let me ask you about that report. Does the field of botany...
Objection to counsel listening comments on someone else's report.
Overrule at this point. I don't know what the question is.
Does the field of botany train botanists to estimate how long a root has been alive if they don't know the root solely by measuring the diameter of the root?
Objection. May we approach?
Dr. Hall.
Just a second. Okay, objection sustained. You may continue.
Thank you, Your Honor. Dr. Hall, when you look at the photographs...
I'm Dr. Bach.
I'm sorry. Dr. Bach. It's been a long day already. Dr. Bach, when you look at photographs that were taken in this case, can you tell us by looking at the photographs how old the roots and the plants are? Just by
No.
looking at the photographs?
No,
Why?
because I don't know what plant those roots came from, and size and growth rates and all those
Can you get
things.
closer to the mic? I'm sorry.
Size and growth rates are characteristic of an individual plant, and they differ greatly among plants.
What kinds of things cause them to grow at different rates?
It may be the mineral nature of the soil, the presence or absence of lots of calcium, nitrogen, water, other plant roots being in the area, water, lots of water or a little bit of water, and so on. In other words, environmental factors.
All right, and if you were to attempt to determine how fast a root grew, what would that require in your field? What would you need to do?
First, you would need to know what plant it came from, and then you would need to do time-spaced observations on growth rates.
And when you say time-spaced observations, can you break that down for me?
Sorry.
And get closer to the mic. I'm going to be on you for that.
You would keep track of how the root elongated, at what rate it elongated, and what size changes occurred.
How would you keep track of that?
With a ruler, with a notebook, with a camera, with whatever you had at hand to help you. Or you could do it in a laboratory.
In layman's terms, you would watch it grow and measure it as it grew over time? Is that what you're saying?
Yes.
Okay.
Yes.
Thank you, Your Honor. That's all I have.
Okay. Cross-examination.
Thank you, sir. Good morning, Dr. Bach.
Hi, Mr. Ashton.
How are you?
I'm well, sir.
You're from Colorado, is that correct?
That's right.
And most of your work has been in that area of the country, that sort of middle area of the country. Is that not correct?
No, that's not correct.
How much time have you spent actually working in Florida as a botanist?
It was the site of my PhD thesis work. And since then, I have had individual research projects in Florida and hope to have more in the not-too-distant future.
And when your PhD is from what institution?
University of California at Berkeley.
And you said your PhD thesis and when was that, if you don't mind me asking?
No, I don't mind. I got my PhD in 1966.
And what was your actual work in Florida in the 60s for your PhD?
Moving up and down the state, looking at the distribution of water hyacinths in freshwater bodies in this state and also in semi-marine areas, estuaries.
All right. And other than that, what other projects have you worked in botany since 1966 that have brought you to Florida to actually work in Florida?
I studied the food habits of the tortoise,
Right.
which is an endangered species, and is a vegetarian.
And when was that?
That was from about 1980, off and on through 1990.
And how did you how did that work actually bring you to Florida? In other words, what would you come for a few days? Did you live here then? Tell us a little about that Florida experience.
My parents lived here. I came to see them. I also had some research support about tortoises in general, and I used some of that support as well.
All right. Any other involvements you've had in studying botany in Florida?
Yes, I was friends with the person who wrote the first flora of Florida. It's the late Robert Long, and I was very interested in the progress on his work. Subsequently, I've used field guides to Florida plants in order to become familiar with the thousands of plant species, native and non-native, that exist here, to further my botanical knowledge.
Was that review recently in preparation for this case, or just in general?
In general, and it continues to now.
And any other involvements with studying botany in Florida, other than I believe you told me about 3 projects?
No.
All right. Now, most of your work has been in studying grasslands and grasses. Isn't that correct?
Part of my work, and a big piece of it, is concerned with grasslands, here and in South America, and yes, here and in South America.
And you would agree that different areas of the country have unique botanical ecologies that differ.
Yes.
Right? Now, you visited the area where this body was found, correct, as you said?
I did.
And you also reviewed photographs of, a large number of photographs of the scene, both in its pristine form and then at various levels of exploration. Would that
Yes.
be correct? And you would agree that this area, based on the botanical specimen seen, is basically sort of a swampy area, an area that's frequently wet. How would you describe it?
It has been characterized in the ecological classifications as a swamp hardwood.
Swamp hardwood.
But that's an interesting term. Part of the plants that are common there are upland plants, not swamp plants, so they aren't wet all the time or frequently. Others are.
All right, so you would characterize as an area that wouldn't necessarily be underwater all the time,
No.
but would frequently be underwater.
Frequent.
Would
I don't know what you mean by frequent.
Well, the plants that you saw there are many of them are species that require a great deal of water.
Yes, at certain times of the year.
So you would agree that the general character of the area is an area that is at least, we'll say, occasionally underwater.
Yes.
Okay.
Or wet.
Or wet. Now, your statements to counsel that you believe this body could have been there for as little as 2 weeks, you quoted the leaf litter, but is that opinion based upon looking at all of the botanical evidence in the case?
Yes, it is. Yes.
So you viewed the roots that are growing through the hair mass, and is it your opinion that those roots could have grown there in just 2 weeks in in December.
Could have accumulated there in 2 weeks, yes.
Well, is there a difference between grown there and accumulated there?
Yes.
Okay. My question was, could they have grown there in 2 weeks?
Yes.
And the roots which are growing through the laundry bag, you recall seeing photographs of a canvas sort of laundry bag with roots growing actually into the fabric. You recall those?
Yes.
Okay. And is it your opinion that that could have occurred in only 2 weeks in December?
Yes.
And the roots that are growing in the bones, did you see the photographs of roots actually growing into the bones in this case? Did you see those?
I saw the photographs. I also saw the bones, some of them.
And are you presenting the opinion that that growth into the bone could have occurred in 2 weeks in December?
I suspect so, but I'm no expert on bones, and I'm not qualified to comment about osteology. But based upon what I know about the ability of roots to penetrate substances, yes.
But you, I believe, have, and I appreciate candidly admitted that you have never dealt with a decomposing skeleton where you had root growth in the skeleton. You've never had that experience, is that correct?
Yes.
Now, sorry, go ahead.
I have in skeletons that had been in place for several years.
So you say you have dealt with?
I have looked at that evidence, and so sometimes yes and no is not so easy.
Okay. Well, let me just put it to you this way. Have you had the occasion to examine a skeleton where plants or roots had actually grown into the skeleton?
Yes.
Okay. Let me direct counsel and the witness's attention. Do you recall giving your deposition on February the 12th of 2011?
Oh, yes.
Okay. For counsel's benefit, this is page 64 going to page 65. Do you recall the following question being asked? Okay, well, let me put it to you this way. Have you ever had occasion to examine a skeleton where plants or roots had actually grown in the skeleton? You said, this would be page 64, line 24. You answered no. However, I've taught classes where I've done experiments getting roots to penetrate heavy, thick articles. I asked bones, and you said, I'm trying to think because they're just amazing. Clay, I don't think I ever used bones. No bones. You said, doesn't sound like me.
Not in teaching. However, I belonged to an organization and was present at a crime scene where there were forensic anthropologists, forensic archaeologists, etc., MDs, and I observed in this perhaps 10-year-old skeleton. By that I mean it had been there 10 years. I did see roots, and so I should have qualified what I said, but I didn't even think about that when you asked me that question.
So when I asked the question, that incident didn't occur to you, but it's occurred to you more recently. Is that correct?
I just calmed down and thought of it.
Okay. But at any rate, you would agree that your experience with roots grown in bones is extremely limited.
Yes.
As you said. Now, in the photographs that you viewed, you would agree that there is leaf litter built up on the skull for at least sort of to the area of the lower portion of the eyes, correct?
I'm not sure what you're
Did you see the photographs of the skull as it was found in its pristine form before any leaves or anything had been removed?
Yes, perhaps. I don't know when individual leaves were removed.
If I may have just a moment, Your Honor. Make sure I've got the evidence number. Yes, Your Honor, I'd like to show, and Mr. Perez, if you could pull up photograph in evidence 211. And may I publish to the witness and the jury?
Yes, you may.
Now, are you familiar with this photograph?
Yes.
Do you agree that this photograph shows that the skull is buried in leaf litter up to about the level of, say, the ear or the nose area?
I see one leaf on top of the bones.
Well, I wasn't asking about the leaf on top of the skull. I have a telestrator here, so I'll mark what I mean. Around this area, you can see that leaf litter has collected around the skull up to about the area above the jaw, sort of covering the opening of the nose. That's how high the leaf litter is, isn't it?
I suppose that's all leaf litter, but it may also be humus.
Well, whatever it is, it clearly has collected to a level that rises to approximately above the jawline and to the level of the nose. Whatever it is, it's collected to that height. Wouldn't you agree?
Okay.
And is it your testimony that that amount of leaf litter can collect and pile up in that form in just 2 weeks?
There are other considerations about this picture.
Well, I would just, if you would direct your consideration to my question, I would appreciate it.
Yes.
Make sure that the witness had finished her answer.
Ma'am, did you finish your answer?
Yes.
Okay, thank you.
All right, so let's also go to now State's Exhibit 213 in evidence, if I may publish that as well.
You may.
Thank you. This is, do you recognize this as a photograph of the skull when it is returned to the medical examiner's office with the leaf litter around it collected with it?
Yes.
And would you agree that this reflects leaves of widely varying degrees of decomposition?
Yes.
Some of them retain are still green. Some of them are sort of yellow, and some of them are brown, and some of them are completely gray. Do you recognize that?
Yes.
Is that a reflection of a variation in decomposition level?
It also is a reflection of when the leaves fell from trees.
All right.
Some fall from trees when they have no chlorophyll left. Others are blown in to a place. Others shed their leaves when they're still bright green and the chlorophyll hasn't retreated.
But is it your testimony that all of these varying levels of decomposition in the leaves immediately around the skull could occur in just 2 weeks in December?
Are you talking about the left side of the skull or the right side of the skull?
Either side.
because I don't understand exactly. I did read. I don't understand exactly how this collection was made.
If I might, for purposes of my question, if you would accept the following hypothetical, that the medical examiner investigator put his hands approximately 6 to 8 inches on either side of the skull, reached into the ground to dirt level, and attempted to the best of his ability to lift the entire leaf litter both around and under the skull intact to the best of his ability.
And undoubtedly collected things and must have moved some toward the skull.
I think it would be hard not to. But do you recognize in this photograph a widely varying group of decomposition rates? Or that these leaves have fallen at all different times and at various levels of decomposition, correct?
Yes, I imagine some were.
And some of these leaves clearly have been off the trees for a lot longer than 2 weeks, haven't they?
And lying under other things, perhaps.
My point being, if these leaves are in fact the level that has fallen since the skull has been there, then clearly the skull has been there for a lot longer than 2 weeks. Wouldn't you agree?
Given your hypothesis that it had...
Go ahead.
Given your hypothesis that it had lain there undisturbed all that time, the answer would be yes.
Then what is it that you're basing your 2-week estimate on, if not the very leaf litter that we've just discussed?
The fact that the litter in the picture that was displayed up there,
Which picture?
the big cardboard picture.
Oh, the picture that taken when you were there.
Yes.
Okay, in February. All right.
All the leaf litter that was there was accumulated on ground that was scraped bare by the 15th of December.
Are you familiar with leaf fall rates for trees indigenous to Florida? In other words, what times of year they drop their leaves, at what rate? Are you familiar with any of that information?
Yes.
If I may. I believe. Is this the one you're referring to, Defense Exhibit 29?
Yes.
All right. So what you're saying is that because there are the amount of leaves on the ground here, which occurred in approximately 6 weeks, but the leaf litter isn't covering the ground, is it?
In some places it is, in some places it isn't.
Where do you, may I pursue this?
May,
Do I need a lavalier, Judge? Can anybody hear anything?
it would help tremendously if you did have one.
Can you hear me now? I turned it on. Oh, it's on now. Thank
on
you.
now.
We got it. May I have the witness step down? That might actually be
Yes.
easier. You would step down, Doctor? Now, Doctor, and just sort of step to the side there so the jurors can see, you would agree that largely this area, most of what you see is bare ground or bare roots, not covered by leaves. Is that, like, this area here is bare, this appears to be some sort of root here. What area do you feel is covered with leaves? You're talking about the area to the left of the photograph. Now, is it your testimony that the amount of leaf litter seen in this photograph is greater than the amount of leaf litter built up around the skull?
It could be the same as.
Okay, I'm sorry. We probably need a lavalier for her, too. I apologize.
I can use my professorial voice.
Well,
it could be the same as.
is that good enough for everybody? Okay. Professorial voice will be fine then. All right. But so your position is that this leaf litter we see here, even the greatest accumulation, is equivalent to the leaf litter going up approximately to the victim's jaw line or nose that we saw in the photographs. Your opinion is those are the same.
The leaf litter that was obvious in that picture certainly is equivalent to that.
Did you measure the leaf litter in any of these areas of accumulation?
No.
Now,
did anyone else do that?
Neat thing about this is you don't get to ask me questions. But that's okay. That's okay. Now, I'm sorry, Tim. Now, in this condition, you would agree that this area has been stripped bare not only of ground vegetation, but of overhanging vines, correct?
Yes, according to what I read, but I wasn't there then.
Well, you've seen the photographs.
I have.
And you would agree that the photographs show this was a densely overgrown area with a number of overhead vines, etc. Very dense.
Yes.
Right. Now, this configuration would permit leaves to blow and build up in particular areas, correct?
Sure.
That might not necessarily be the same in the scene photos where you had heavy vegetation that would have prevented leaves from blowing and collecting in certain areas. Wouldn't you agree?
No.
In the area where the body was found, when it was pristine, is it your testimony that there was nothing impeding the blowing of leaves through the vines and the overgrowth and all the other stuff?
There are complications to things flowing freely here. And
why are there no leaf fall on the right side of the photograph as opposed to the left side of the photograph? Can you explain that to the jury?
Excuse me. Let me interpose an objection, Your Honor, because I think it misstates the evidence.
Judge, the photograph speaks for itself.
Overruled.
You would agree that this side of the photograph has considerably less leaf fall. That is, the right side of the photograph, if you're facing it, is considerably less than the left. You would agree with that?
Yes, at that moment in time, it does indeed.
So, I guess my question is, why is that?
I can think of several possible reasons.
Okay, go ahead.
People trampling around. This was a frequently visited spot after the recovery became public knowledge. And that's one possible explanation.
What other?
Wind action is another. Animals is another. And the nature of the trees themselves, just as root growth depends upon the kind of plant it was, similarly, leaf fall rates depend on the kind of plant it was. This flora is not, it's semi-tropic. Some of those plants are evergreen and keep their leaves all year round, but that's deceptive. They shed leaves all the time. The They drop pine needles. The other evergreen trees are constantly shedding a few leaves at a time. Other plants in this forest, certain species, just drop leaves in the fall.
Now, it's important in comparing this photograph to the photographs of where the skull was found to compare apples to apples, to compare the same spot to the same spot.
Yes.
Where on this photograph was the skull?
To the best of my understanding, because I was not there with someone who absolutely knew it was right in here.
Well, you don't really know.
No, but I was told that this particular tree had significance.
So you were told by somebody that wasn't actually there when the skull was removed by Mr. McKenna, correct?
Mr. McKenna had visited this site several times before I did, the week before I was there, with people who seemed, who should have been informed, and I suspect were informed.
Okay. Who was that?
Linda Bodden?
Was it some defense attorneys in the case? Without saying names, is that who you're talking about?
Yes, and and other expert witnesses, too,
Okay.
forensic scientists.
Now, so your opinion, your impression was it was exactly where?
It was in this area.
Somewhere in this area here.
Yes?
Okay. No further questions. Sorry, have a seat. Thank you very much. No further questions on that issue. I just have the bottom line, though, Dr. Bach, is you are not prepared at this point to render any opinion to this jury about when Kaylee Marie's body was left at that scene. You can't render any opinion. Is that correct?
I thought I had rendered one.
Well, so let me ask you this question. Are you prepared to render an opinion in this case as to when the remains of Kaylee Anthony were placed at the location they were found?
No.
Okay, so you are not prepared to render an opinion as to when they were placed?
I did render an opinion.
Now you've lost me. Are you rendering an opinion as to when you think these remains were left there?
A couple of weeks before.
Do you recall me taking your deposition again on February the 12th of 2011, page 68 for counsel line 16? I ask you, okay, are you prepared to render an opinion in this case as to when the remains of Kaylee Anthony were placed at that location they were found? You answered no.
I don't remember what went on before that and after that with your questioning, but if I said it, I meant it. However, it was tendered.
May I approach the witness? Just want to let you take a look at it. If you want to read the context, feel free.
We were discussing Greeley, Colorado at the time, but I know why I said that.
Okay. Did you explain to the jury why you answered no in February and apparently yes today?
I don't know exactly when it was placed there. My best guess is what I have presented today.
Well, now, on direct examination, you said that, in your opinion, it was a minimum of 2 weeks. Are you now indicating that it was a maximum of 2 weeks also?
No.
So you're not of the opinion that the body had only been there for 2 weeks? correct?
It's possible.
Okay. It's also possible it was there for a great deal longer than 2 weeks.
Yes.
No further questions. May I approach to retrieve the deposition?
You may.
Oh.
Redirect.
Dr. Bach, you were asked questions about how long you'd studied plants in Florida. And then I think you mentioned that it was a semi-tropical area, the area in which you viewed where the remains had been found. Is that correct?
Yes.
All right. Let's be more specific. How many years have you studied plants, vegetation, and botany in semi-tropical areas?
30 years.
Okay. And how many years have you taught plants and botany and roots, growth, etc., in areas growing in semi-tropical regions similar to the areas in which the remains were found?
Throughout my time as a professor, 31 years at least.
All right. And if a bone fragment has a hole in it, can you tell me whether or not a root can grow in the hole?
No.
A root fragment, if there's well, let me put it another way. If there is an opening, whether it's a bag or any substance, is it possible for a root to grow into that opening?
Depending upon what kind of root it is.
Okay. You were asked about leaf litter. Did you see the log or the tree that was near the remains?
Yes, I did.
And did you see fallen leaf litter on that log?
No.
And what is the significance to you of that, if any?
It inspired me to look at that log.
Why?
Because I was curious about whether it had been turned over, whether it had laid in that position for a long time.
And was there any documentation in any of the material that you reviewed that weighed the log or identified how long it had been there or determined what specific vegetation was around it, was under it, was on the side of it?
In Officer Welsh's summary reports, she discussed that it took 2 people to move it. So I suppose it was heavy.
Was there an identification of the plant material under the log
No.
or to the side of the log? What information could that have given you?
Objection calls for speculation and relevance and exceeds the scope of cross.
Overruled.
I believe it could have indicated how long the log, the tree, had been in that position, had it been moved, how far along decay was, and something more about other plants in the area, perhaps.
All right, and you were asked about humus and leaf litter, and I'm about to, if, with the court's permission, approach the pad and make a drawing.
Okay.
And ask the witness to stand down, if possible.
You may. Doctor.
Do I need the lavalier? Could you draw humus for us, Dr. Bach, and then draw leaf litter on top of that? And could you use your professorial voice?
Yes. Soil is made up of a series of layers, and the top layer is called the humus layer. It's the layer usually that has the most organic matter in it, broken down plant parts and animal parts, insects, bacteria, and so on. And as you move down in the soil, it becomes less and less organic. That is, it becomes more and more pure rock and sand. So this line is the top of the soil. The humus layer is this top layer. And on top of this, that sketch represents leaf fall, but it could be other things as well. It could be twigs of various sorts. And in this case, remnants of roots of things sometimes appeared right on top of the humus area. Those eventually, through the process of decay, will be incorporated into the humus.
Okay, thank you. And let me ask you a question. On the date in which the photographs that you observed that you understood to have been taken on or around the time in which the remains were found, what were the conditions? Was it wet?
Your Honor, could I object and ask counsel to identify which photograph by evidence number?
Well, the photographs that you were shown.
Your Honor,
Sustained, need to identify it by the evidence number so the record will be clear.
All right, I'll just rephrase the question, Your Honor. When you looked at the photographs which had the remains in place prior to their being moved, can you tell me, please, what the conditions or moisture appeared to be during that time?
same objection, Your Honor. We need to reference a photograph so we know what the doctor is.
I'll move forward. I'll withdraw it and move forward.
Okay. Question withdrawn.
All right. Doctor, if you have an item and you place it on leaf litter and the area is very wet and the humus is very wet, can that item sink?
Of course.
Thank you.
You may resume your seat, Doctor.
Thank you.
Your Honor, that's all I have of this witness at this time.
Any recross?
Could I ask counsel to move the easel back if they're done with it? Thank you. Doctor, is it your testimony that the skull in this case sank into leaf litter or humus or anything like that?
It could have. I don't know.
Or it could not have?
Or it could not have, or it could have been pushed. I don't know.
Or it could have been laying on top of the leaf litter, and the leaf litter, by a natural process over several months, collected around it. That is also a possible explanation
Yes.
for it. Were you aware that one of the bones from this skeleton was buried in 4 inches of muck
No.
or humus? If you had that piece of information, that by operation of time or operation of water movement, that one of the bones was buried 4 inches into what is described as muck, would that not tend to indicate that this skull had been there for a great deal longer than 2 weeks?
The skull was in,
I'm sorry, a bone, a hip bone, was buried in 4 inches of what is referred to as muck, which I assume is wet. I assume you would call wet humus. Wouldn't that indicate pretty conclusively that this skull had been there a whole lot longer than 2 weeks?
or a dog buried it?
I'm sorry, a dog buried
They
it.
do, as do coyotes. I don't know if you have those here.
No, we're not blessed with coyotes. But we have a lot of other things. Thank you very much, Doctor.
Okay, may the doctor be excused? Yes, sir. Thank you, Dr. Bach. You may be excused. Okay, ladies and gentlemen of the jury, we're going to take a recess at this time. Special one? Okay. All right, we'll take a recess. I'm going to give the jury 20 minutes, but I'm going to give the attorneys 15 minutes. There's a matter we need to take up before they come back in here. Jury will be in recess for 20 minutes. You will be in recess for 15. Okay, court will come to order. Mr. Baez, who is the defense's next witness.
Richard Eichenbaum.
Okay. I have reviewed the requested instruction that the state has proposed, and I've reviewed the instruction that the defense has proposed. Now, did Dr. Eichenblum provide a partial report?
No, Your Honor. He provided an affidavit, and he, in deposition, referred to it by that term as an affidavit. It does not. I provided the court with a copy of it the other day, and
Well, this is what I'm looking at. It says affidavit R. Eichenblum dated January 21st, 2011. Is this what he provided?
yes, Your Honor, that's the item that was provided
Okay.
through defense counsel.
This is the instruction I propose to give. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reason for those opinions or conclusion, and 3, in a data or other information considered by the witness informing their opinion or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging the credibility of the witness's testimony. Mr. Baez?
Yes, sir. We maintain our objections since I have withdrawn the areas that were previously at issue. We would just, for the record, object.
Okay. Before I do that, I need to have the witness come in, and I need to make an inquiry of the witness, and then I need, before I formally impose the sanction, I need to make a 3-prong finding for purposes of the record. So let's have the witness come in. I have a few questions I need to ask him. I will file this first item is the defense's proposed instruction if I was going to give an instruction. The second item is the state's handwritten requested instruction.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
My name is Richard Eikelenboom, Eikelenboom, Eikelenboom.
Doctor, I'm Belvin Perry. I'm the presiding judge in this case. When were you first retained by the defense?
The first investigation was, or the first request, official request, for the case was when we had to look over the evidence.
And when was that, sir?
That was on 13 July 2010. And of course, it was a couple of days before that.
July 2010.
Yes.
Sir, were you ever informed that you were required to produce a report outlining the opinions that you rendered in this case as a result of your examination of the evidence?
Except for the affidavit, I was not told that I had to render opinions or write another report.
Sir, were you ever informed of the following? Where expert witnesses have not prepared reports of examinations or tests, both the state and the defense are required to provide the following information, which shall be filed with the clerk of the court in form of a written pleading. 1, the expert's curriculum vitae or qualifications of the expert. 2, the expert's field of expertise or medical specialty. 3, a statement of the specific subjects upon which the expert will testify and offer opinions. 4, the substance of the facts which the expert is expected to testify. And 5, a summary of the expert's opinion and grounds for each opinion. Were you ever informed of that order of the court?
No, I don't recall that order.
Okay. I take it, sir, that you do not live in the continental United States?
Well, actually, since February, we're living in Conifer. But before that, we were living in the Netherlands.
Okay. How were you communicating with the defense? Was it by phone, email, or by what other means?
By phone, email, and Skype.
Were you ever requested or asked between December 2010 and May 1st of 2011 to reduce your opinions and findings in writing in a report format as I've just outlined?
Sorry, reduce? I mean, to write a report?
To write a report in the format that I've just outlined, sir.
No, I don't recall that.
Okay. Who was the principal person that you communicated with for the defense? Who were you getting your instructions from?
Mr. Baez, and we also had communication with Michelle.
Okay. Now, from May of 2011 up until today's date, were you ever asked to reduce your report in the written format that I've just outlined, which would include all of your opinions that you were asked to produce?
Last Saturday, I talked with Mr. Baez, and then after we went to the district attorney's office to do the deposition where we were refused, it was requested that I would write a report. So last Saturday night, we wrote a short report.
Between December 1st in the year 2010 up until May 1st, 2011, how many times have you communicated with members of the defense team?
Well, I'm not completely sure about that. I know we had communication short before we had to do the inspection of the evidence, and short after, and then for a long time I didn't hear anything anymore. So we more or less lost contact and lost track of the case.
From December 1st, 2010 up until May 1st, 2011, were you readily available to be contacted by the defense team via email, telephone, or Skype?
Yes, the defense could reach us if they wanted, yes.
You didn't disappear during that time period, did you, sir?
No.
Okay. Either the state or the defense want to ask any questions along those lines that I've just asked.
Yes, sir.
You may proceed.
Mr. Eichenbohm, is this the first time anyone has ordered you to write a report on a case?
To write a report on a case?
No, not on a case, on that had certain parameters like this one.
Oh, in the Dutch courts, yeah, you sometimes get a request, and that's by an investigative judge, and they can order you to investigate certain evidence or certain reports, or and write an opinion about these items.
And that would be based on things you've done, correct? Like run certain samples of DNA, inspected certain pieces of evidence.
Can be both. Can be on investigations which we have performed, but can also be on investigations of other laboratories, and then they want a second opinion about the methods used or conclusions drawn in those reports.
Okay. And the contact with your company back in January of 2011, that was done through your wife and Miss Medina, was it not?
Yes.
It wasn't
correct.
directly with you?
No.
Okay. And in fact, what occurred and how this order was, the information got back to you came originally from Miss Medina to your wife and from your wife to you.
That's correct.
Objection assumes effect not in evidence that the information about the order ever got to the witness. He's indicated it didn't.
I permit him to go ahead. Objection overruled.
Okay. Now, what you ended up doing is based on what your wife ended up telling you, correct?
Yes, you're talking about a very short affidavit.
Yes, the affidavit. Okay. And what you in turn ended up doing was filling out an affidavit of all the work that you had done up until this point, correct?
Yes, this is more or less about the evidence viewing.
Which was, you wanted to inspect a piece of evidence for your own testing, but it was denied, correct?
Yes.
And then also that you had actually gone and done an inspection of the evidence, correct? And took photographs.
That's correct.
Were you ever told in any way, shape, or form to narrow your report or to exclude things from your report?
No.
Okay. And the report or affidavit that you ended up submitting was based on what you thought was required of us.
Yes.
And you never spoke directly with Ms. Medina about what the court has actually ordered.
No.
That conversation actually took place with your wife and Ms. Medina, correct?
That's correct.
And then later on spoken to you, correct?
That's correct.
Do you recall exactly what your wife told you was required by the court? If you can remember.
No, I don't recall that.
Do you remember that conversation at all, only that maybe it happened?
No, I don't remember the conversation at all. And the affidavit, I remember something about the affidavit, but we were very busy in that time. We were in the transfer time that we transferred from the Holland to the United States. So I didn't think much about this affidavit.
And the questions and the opinions that you raised and formulated on Saturday, they were first broached on Saturday, correct?
Yeah, when we were talking about the case in Saturday afternoon after the court session, then the idea came up to write a report or to form ideas about what topics we were talking about.
And these are not opinions that you held before and had discussed with us previously, and we determined that you were going to testify about these opinions prior to Saturday, and you just didn't not include them in your report, correct?
That's correct. On Friday, I made a PowerPoint presentation, and just an average presentation for explaining contact DNA.
And Friday's PowerPoint presentation was just a general explanation of touch DNA and nothing more.
Yeah, and how PCR works.
They weren't specific as to any of the issues that were raised in this case, only an attempt to explain touch DNA.
Yes.
Okay. And upon our conversation on Saturday, you were then immediately asked if you would consider taking a deposition at the state attorney's office to now discuss these new opinions.
Yes, so during the lunch, we discussed the topics, and then about which I might be allowed to talk during court, and then we had an appointment with the district attorney's office to do deposit.
Okay. And what happened when you showed up at the state attorney's office?
We were refused entrance.
By who?
By the district attorney.
Who? Is he sitting here?
Yes.
I'll stipulate it was me.
Okay.
It'll help.
And what exactly did he say?
I don't recall exactly what he said, but as I understand it, I was at least not going to do a deposition.
Was he polite?
That sounded kind of rude.
Okay. And after that occurred, were you then instructed by Ms. Medina to immediately do a report?
Yes.
And you did that?
Yes.
And then you emailed that to me Saturday night?
That's correct.
Okay. I have no further questions.
Mr. Ashton, any questions?
May I just do it from here, Your Honor?
You may.
Is there any opinion that you have expressed in your Saturday afternoon report that you could not have developed 4 months ago through the same conversation with Mr. Baez?
It depends on the information which was available at that time, but like DNA reports, that probably could have been, if asked, I could have written a report about that.
Did he give you any new information during, and you spoke at lunch on Saturday?
Yes.
Correct. Did he give you any new information during lunch on Saturday that you had not been provided with before?
Well, for me it was new information because I didn't follow the case. So the case, when we left, we got a subpoena a week ago, or it's almost 2 weeks ago now. So the case for me was not really clear, and I know, of course, about the case, but I really didn't follow it. So for me, maybe the information was there, but for me the information was not clear, and it was not clear which direction everything was going. So I needed that guidance during the lunch.
I understand you may have gotten new information about what Mr. Baez was interested in, but did he give you any new reports, any new factual information that you didn't have already?
I got, I think that was during Friday and Saturday. We got new information, so about crime scene pictures and some extra reports.
What new information?
Reports from the FBI and some extra pictures.
So you hadn't had the FBI reports before Friday?
Not all of them, no.
What new ones were you given? What new FBI reports were you given on Friday?
Oh, I just, actually I got the whole folder, so.
Well, can you give us any more guidance on what you had already and what you got that was new?
I've seen reports before. That was, I think that was during the investigation of the evidence. So I form an opinion about the case, and I know something about what was already then. And during last week, I requested for more information, digital, and I got all the reports, which were then, that's a lot of reports, of course.
And you made that request after you got the subpoena and realized that they were actually going to want you to testify?
Yes.
No further questions.
Okay. Pursuant to Richardson versus State 246 7 seconds 771, a 1971 decision of the Florida Supreme Court, as amplified in McDuffie versus State 977 second 312, a 2007 decision of the Florida Supreme Court. The court will make the following finding of fact. 1, whether the discovery violation was willful or whether or not it was inadvertent. On December 10th, 2010, the court entered an order. The order was entitled Order Granting State's Motion for Clarification / to compel compliance with order for additional discovery. On December 1st, 2010, the state filed a motion to clarify. At a subsequent hearing, it was determined that there was some dispute concerning a prior order that the court had entered and the intent of certain language. The exact language of that court order at the time provided as follows. The defendant shall also provide to the state a list of the defendant's experts that shall include the subject matter as to what the expert would testify to and the area of expertise for each expert. The court goes on to say there was some debate about the word subject matter rather than substance. The court said while the order included the term subject matter rather than substance, the court finds that the list provided by the defense does not comply with the intent of the order or the intent of the court as expressed in its November 29, 2010 hearing. In order to clarify this issue, the court went on to order the following. Where expert experts have not prepared reports of examination or tests, both the state and the defense are required to provide the following information, which I have previously outlined. The court at that time thought that the matter was clear. In January, the court was back again to deal with this issue again. Going back to the December 10th order of 2010, the court specifically provided, with respect to all other experts, this information is to be provided by 3 p.m. on Thursday, December 23rd, 2010. There were some different deadlines with respect to Dr. Fairgrave and Dr. Bach. That information was to be provided by December 14th, 2010. Again, we had the same problem again, and the court again specified what information and reaffirmed its prior order and assessed sanctions. The obligation are for the attorneys to see that their witnesses comply with the orders of the courts. It is the attorney's job, be it the assistant state attorneys or defense counsel, to make sure that their expert witnesses comply with the order of the court. The court will find that this violation is not inadvertent, that it should have been clearly communicated to the expert, and that the expert should have been required to comply, and the expert was not. Therefore, the court finds that the discovery violation was willful and not inadvertent. The next issue is whether or not it was trivial or substantial. DNA, even though the advent of DNA evidence has been around for a number of years, certain opinions that will be expressed by this witness as a result of the deposition, which is now on file, cannot be viewed as trivial when we start talking about rendering opinions with the of analyzing decomposition fluid in a trunk. So the court finds that it is not trivial but substantial. The next issue is whether or not it had a prejudicial effect on the opposing party in the preparation of their particular case. The court has delayed the testimony of this witness in order to give the state of Florida an opportunity to take this witness's deposition. If the witness had authored a report, put his opinions, the basis for his opinions, and the data which he relied upon with those opinions, then this court would not have given the state an opportunity to take his deposition, because they chose not to do it. If those items would have been in his reports, then the state would not have had the opportunity. The question comes in as to whether or not I need to totally exclude his opinion about the possibility of a DNA analysis which may have some Frye implications, and this court cannot, in this short period of time, make that particular determination. All of the cases indicate that the exclusion totally of testimony is an extreme remedy to be utilized in rare circumstances. The court has decided to do the following. At this juncture in time, the court will not permit the witness to testify on this particular issue dealing with the possibility of a DNA analysis on the decomposition of fluid in the trunk of the car. The court will give the defense until next week by Saturday to file whatever potential motion it wants to lay out for a Friday hearing, and the court then on Wednesday evening or Thursday evening at the conclusion of the day's testimony, after a 1 hour break to give the attorneys an opportunity to get something to eat, then we will come back and conduct whatever Friday hearing we would need to see whether or not this testimony does meet Friday, or whether or not there is even a Friday issue involved in that particular testimony. That should give each side ample opportunity to do what they need to do, and it is a remedy short of exclusion, but I will not permit this testimony at this particular time. Anything else on behalf of the defense or the state?
Not on this issue.
Okay.
I have a brief issue that I'd like to bring to the court's attention.
Yes, sir.
Today, we were handed by the state of Florida discovery, which concluded 2 compact discs.
Okay, we'll take that up at noon
Yes,
on
sir.
your lunch hour.
Yes, sir.
But we got a jury that's sitting in there. Yes, sir. Yeah.
And I want to also make sure that you remove from the PowerPoint any issue, anything related to the issue about
DNA from decomp fluid needs to be removed from the PowerPoint.
I believe we're ready, Judge.
Okay. All right, let's return to jury. Okay, Madam Clerk, may you swear the witness, please?
solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God.
I do.
Okay, ladies and gentlemen of the jury, let me give you the following instructions. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reasons for those opinions or conclusions, and 3, any data or other information considered by the witness informing their opinions or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18, 2011. You may consider this fact in judging the credibility of the witness's testimony. You may proceed.
May it please the court? Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Mr. Eichenbohm.
Morning.
Actually, can you state your name for the record
Richard Eikelenboom.
and introduce yourself to the ladies and gentlemen of the jury? Sir, what is your profession?
I'm a DNA scientist.
Okay. And You have an accent. Where are you from?
Oh, I'm from the Netherlands, so I apologize for my accent.
Now, can you give the ladies and gentlemen of the jury a little bit of your educational background? Can you explain that to them?
Yes, I started working for the National Lab in the Netherlands, which is at that time was the only laboratory doing all the homicide and crime cases for the Netherlands in early 90s. And I started on the Department of Serology. The Department of Serology later became Department of Biology, because in the early 90s in the Netherlands we also started with DNA. So I started on the serology department doing protein electrophoresis and blood group typing, which is the front runner for DNA. So later on, I became more involved in trace recovery, so finding the stains.
What does trace recovery mean?
Trace recovery, well, actually, for the biology department, is finding all kinds of biological cell material which could be used for either electrophoresis at the time in the beginning and later on could be used for DNA profiling.
And have you had any other training on DNA?
Yeah, I went to laboratory school first. That was analytical chemistry, so that was not really in the field of biochemistry. And then during my working for the National Laboratory, I followed an education on biochemistry. Okay. And that means biochemistry, you work with DNA and you try to decipher DNA. So it's all involving decipher DNA, so it's all about DNA.
Okay. Now I'd like for you to speak as close to the microphone as possible so everyone can hear you a bit clearer. Now, how long have you been working as a DNA scientist?
Around 20 years now.
Okay. And how long did you work for, was it the Federal Police Department of the Netherlands, or?
No, the Netherlands Forensic Institute is under the Justice Department. Our system is a little bit different from the United States. So I was working for the Justice Department for around 13 years.
Okay. And after that, where did you work?
In 2005 or 2003, my wife started the company Independent Forensic Services, and I joined the company in 2005.
Were you ordered to do that?
No.
Okay. Now, sir, can you explain to the ladies and gentlemen of the jury what the difference is between regular DNA and low copy number DNA?
Objection, Your Honor. The witness has not been qualified as yet, and I have one other question.
Okay.
I'll pass over for qualification for the voir dire, and then I'll continue. Michael, take that stuff. Let's go take it. Mr. Eichenblum, the highest degree that you have obtained is what's referred to as an engineer's degree in Holland. Is that correct?
That's correct.
And that engineer's degree is something between a bachelor's degree but not quite up to a master's degree, somewhere in between those two, correct?
That's what you could say, yes.
Approximately. Your degree is in biochemistry, correct?
That's correct.
And your specialization for your degree in biochemistry was in the study of luminol, correct?
That's correct.
That's a substance that is that lights up to show where blood is, correct?
Yes, it reacts with oxidized metals.
Okay.
But it is used, in CSI a lot for finding bloodstains.
But you did not specialize in molecular biology or DNA in your biochemistry degree. That was not your area of specialization, correct?
That's not correct. Of course, the biochemistry education has biology, all kinds of fields and training in DNA and biochemistry. And then as a part of the last year where you do an internship, which of course was at my work, then I choose for a luminol subject. So that subject didn't contain much DNA. Of course, we were finding out, so actually it did contain quite a lot of DNA. What we tried to find is to make a new solution of luminol, which would not deteriorate DNA. So it had for sure something to do with DNA.
Now, when you were working at the same time you were in school, you were also working for the Netherlands Forensic Institute,
That's
Department of
correct.
Biology. But you did not do DNA testing for that institution, did you?
I worked on the biology department, and the biology department is divided in sections. And during the time we're talking about my training, I became a coordinator, and that means that you coordinate cases, you get all DNA results, but it's all on paper, and I had you can have an accent on certain investigations. That could be DNA extraction, that could be analysis. My emphasis was on trace recovery.
Not DNA analysis or extraction.
No.
And in fact, though you had some training in DNA with the laboratory, you were not certified by that laboratory to perform DNA analysis, were you?
That's correct.
You did trace recovery.
Yeah, as an accent, and I coordinated cases and reported cases.
Coordinating cases means basically deciding which unit should get it first, how best to coordinate the various disciplines in examining an item. That's what you mean, correct?
And then you get all the results. So you have to know something about DNA in order to do interpretation. So analysis, in the sense you get the results, but you do the final comparison about suspect, victims, match or no match.
But you didn't actually perform, analyze, or interpret DNA cases during your period of time with that institution, correct?
I did a lot of interpretation. I did not do the performing the actual pipetting of extraction or analysis in the unit analysis. But
I see. But in 2005, your wife and you opened a business
correct.
called Independent Forensic Services.
Correct.
And you and your wife appointed you as, quote, director of DNA.
Correct.
No further questions, Your Honor. We would object to his qualifications as an expert in this area.
I have more that I'd like to elicit from him.
Go ahead.
How many cases did you work where you actually recovered DNA and processed it in the Netherlands?
In the Netherlands.
Yes.
Processed the DNA cases, so that was during Independent Forensic Services?
Correct. Prior to opening up Independent Forensic Services.
Prior to?
Yes, yes.
So, what I said for the Netherlands Forensic Institute, I worked on, as a coordinator, I worked on a lot of high-profile cases, but then as coordinator, you get the results from the laboratory technicians. During the time with Independent Forensic Services, we started doing everything ourselves. We didn't have lab techs. So in that time, we did from trace recovery till the report writing and court testimony all ourselves.
And did you receive any training on how to do these, how to do both the trace recovery, extraction, and PCR process, and everything else that is required when running a DNA sample?
Yes, of course. We had during the biochemistry lessons, you get to know the DNA extraction. And in the Netherlands Forensic Institute, I followed all courses which were aligned to become an expert witness there.
Okay. And was your lab, Independent Forensic Services, accredited by any organizations?
Yes.
Which organizations?
In Holland, we have a Dutch accreditation board, and that is similar to what you have over here as the ESCLET accreditation. That's a board which accredited DNA laboratory or for all kinds of laboratory, but in this case, DNA laboratories.
And do they require certain proficiency testing?
That's correct.
Okay. And what is proficiency testing?
With proficiency testing, you get a blind sample, and in this case, or in our case, we used CTS because we know it's an American-based company, collective laboratory testing. and they send out a sample or more samples, reference samples, and as a crime sample, and then the laboratory has to perform DNA on that and then send back the results without knowing whether or not they were right. And after you send that in, a couple of months later, you get results back and you can see whether or not your test has been performed well according to 160 or more laboratories which were participating in that test. And till now, we always met the criteria of the other laboratories.
And have you, has your laboratory been contracted by law enforcement from your country to
That's
do
correct.
DNA samples?
Yes.
How many times?
Over 100 times.
Okay. And in addition to that, have you ever been asked to testify as an expert witness in the area of DNA analysis?
That's correct.
How many times?
Over 70 times.
I'm sorry?
Over 70 times.
70 times. Okay. And to get this accreditation, are there any other requirements that they monitor your laboratory and its employees?
Well, the CTS testing is a very important one, of course, but also when the Board of Accreditation does a visit over here, I'm not sure. In the Netherlands, that's every year. I think over here it's once every 2 years. But in the Netherlands, every year they come by and they also bring an expert, a DNA expert, a forensic DNA expert who can say and review reports. They can actually ask anything from you. So in that way, you're reviewed very thoroughly.
Are you referring to audits?
Yeah, the audit.
Okay. And how did you become involved in cases in the United States?
Well, the first case was the Tim Masters case.
Okay.
Objection to reference to specific other cases.
The counsel is the one that's questioned his qualifications.
Sustained, you can ask him whether or not he's testified, but don't talk about a specific case and whether he's been qualified in courts over here.
Yes, sir. Mr. Eichenboom, try and answer just my question. You were contacted from a case from the United States, correct?
That's correct.
And what kind of case would you call it?
Objection doesn't go to qualifications.
I think it does.
Sustained, rephrase the question.
Were you sought out for your unique expertise in any?
Move to strike.
Sustained.
Were you sought out for what reason, sir?
Objection. Relevance. Could we approach Your Honor?
Yes. You may proceed.
Thank you, Your Honor. Mr. Eichenboom, have you been sought out to handle cases in the United States?
Objection. Objection.
Sustained.
Have you testified as an expert witness in the United States on some cases?
Yes.
Where and how many times?
State of Colorado, 2 times.
Okay. And were these by law enforcement or defense or both?
I have to correct that. It's 3 times. Twice by defense, 1 time by law enforcement.
Okay. And you now have a laboratory in Colorado?
We're setting that up.
Okay. And the training that you've received in DNA analysis, where did you receive that training?
A lot of the training was in the National Lab in the Netherlands Forensic Institute.
Okay. What kind of courses?
All kinds of courses. It's a laboratory training. It's about interpretation, analysis, statistics, moot courts. So the whole field.
Would it be fair to say from the actual recovery of a collection of evidence all the way through the statistics of being able to interpret results you've received training on?
To the court, yes. So statistics
Actually, even
before that.
through the court. Okay. And was this accredited training?
Well, I think it's part of the accreditation procedure. If the training itself is accredited, I don't know.
Okay. And did you also have experience in all different aspects of DNA analysis?
Yeah, maybe I should explain that the reporting officer, I was in training for reporting officer, and then you, of course, have to know everything about the topics about DNA, which you have to testify in court. In the Netherlands, because the laboratory or the biology department became so big, it was separated. So you did not, as a reporting officer, you don't have to work at DNA extraction or DNA analysis. You, in this stage, they have reporting officers which have never been in the lab, I think. So to become a reporting officer, you have a different training than if you only do trace recovery or you only do DNA extraction. That is done more by lab techs. So the difference was that I went from trace recovery to become a coordinator and to become a reporting officer.
Okay. So is it fair to say you've received training on all aspects of DNA?
Absolutely.
Okay. And that you have over 20 years experience on being able to identify issues on all aspects of DNA?
That's correct.
And you've been certified both as an expert witness 70 times in the Netherlands and 3 times in the United States?
Yes, that's correct.
And you've been certified as an expert witness in DNA analysis?
That's correct.
At this time, Judge, I would submit Mr. Eichenboom as an expert in DNA analysis.
Say it wouldn't maintain its objection.
Witness would be accepted as an expert witness in DNA analysis.
Judge, would this be a good time to break for lunch?
It would be a good time, Mr. Baez. Okay. Ladies and gentlemen, jury, we're going to recess for lunch. I'm going to ask that you return here at 1:30. Do not discuss this case among yourselves nor with anyone else. Thank you. Okay, Mr. Baez, you said you had another issue you wanted to raise.
Yes, sir.
Sir, you may stand down. You can go to lunch. Be back by 1:25.
Sir, Judge.
Let's get the witness out. Make sure your staff tells him what time he needs to get back. You may proceed, Mr. Baez.
Your Honor, we were given this morning, which is the date, June 21st, 2011, some discovery that was provided to us by the state. In reviewing just a crude, rough peruse of what was given to us, it appears that many of the documents that were turned over were items that have just recently come up and certainly beyond the state's control as to being able to turn the items over, with the exception of one compact disc. This has to deal with some material from the desktop computer from the Anthony home, specifically ones that were taken from June 16, 2008. This report was completed on April 26 of 2008, but yet not turned over to us for 2 months later, after the time that the state's experts have already testified, computer experts, that is, specifically. In reviewing this also, I also noticed some photographs that appear to be some internet searches for what would be considered and this is just one example. It's not the brunt of our objection and issue. But it appears that there are photos of shot girls, which may have been at one time viewed on the Anthony home computer. I found this particularly interesting because during Mr. George's direct examination, he on multiple occasions referred to Miss Anthony organizing or trying to collect or give advice on the clothing that the shot girls should wear, which also leads me to believe that the state had prior notice of this discovery, and that's the point why I bring that up. The law enforcement had this computer since July 16th of 2008, going on 3 years now, and this report is now given to us subsequent to the state's experts already testifying. We would object to any presentation having to relate to these items, and I'm specifically referring to the computer items, not to what was disclosed previously, or what was disclosed of recent events that don't appear to be relevant to this case, unless of course they do become relevant at some time. But we would certainly object to that, and I guess I ask for a Richardson hearing on the matter, unless the state does not intend on using this newly found, well, not so newly found evidence.
Ms. Burdick?
Thank you, Your Honor. The first several items on the notice of discovery deal with a brief investigation that was conducted at the end of last week. Apparently, a citizen called the Orange County Sheriff's Office, left some information about an inmate who may have had contact with Ms. Anthony at a point in time when the inmate was in the Orange County Jail. That matter was investigated Thursday or Friday of last week. The report was generated. A statement was taken over the phone from this witness. That transcript was produced immediately. I received all of that information yesterday.
What was the name of the witness?
The name of the witness is April Whalen. Apparently, her child died in a swimming pool and was found by the child's grandfather, who immediately administered CPR and called 911. Ms. Whalen was in an adjacent cell to Ms. Anthony for a very brief period of time. Ms. Whalen indicates to law enforcement she did not talk to Casey Anthony. However, she doesn't remember if she talked to other inmates. So at the present time, it's being explored whether or not there was indirect contact. Be that as it may, as soon as I received the reports verifying that, in fact, Ms. Whalen's son did pass away in a drowning incident, as well as the reports from law enforcement of the follow-up on the information obtained by or delivered by a concerned citizen that was provided to Mr. Baez in the event that it does become relevant in relation to the subsequent investigation or the investigation that continues. The last item that is on the notice of discovery is simply a filtered copy of items from the hard drive that Mr. Baez has had for years. My use of these items, or our use of these items actually, would be exclusively in rebuttal if Ms. Anthony or another witness were to testify about specific activity occurring on June 16th. An examination of the hard drive indicates there was substantial computer activity that would rebut a lot of what Mr. Baez said in opening statement. Therefore, even though he had this information for years himself and had a computer, more than one computer consultant during the pendency of the case, as I recall, I decided that if we are going to use a demonstrative aid during the course of our rebuttal or even Ms. Anthony's cross-examination, that we would give that to counsel. And we have done so, rather than holding it for rebuttal.
Let me ask you these questions. I take it so we're all on the same page. This is contained in notice of provision of supplemental discovery dated June 21st, 2011, which bears your signature.
It does.
And items 1 through 6 all have to do with Miss April Whalen.
They do.
And that information was provided to you by law enforcement when?
The fact that they were conducting an investigation was communicated to me last Thursday or Friday, perhaps even Saturday. I believe they worked on this over the weekend. The written reports were delivered yesterday afternoon.
And so you delivered it as soon as you became aware of it and it was ready to be delivered.
That I did.
Okay. And the last item, item 7, is just a redacted version or demonstrative aid of an item that you had previously given to the defense.
The defense had their expert actually travel to the Orange County Sheriff's Office or provide a hard drive to the Orange County Sheriff's of the HP, the desktop computer in the Anthony home over 2 years ago. And the information contained on the hard drive is, of course, voluminous. I would have expected that counsel would have concentrated on the items on the computer on June 16th. However, since we did that and would like to use some of the items on the computer as a demonstrative aid, rather than having the sanction of exclusion that was suffered as a result of not providing a PowerPoint, I provided this information at this juncture.
Now, do you plan to utilize Ms. April Whalen?
Based on her statement, I would say no. However, as that information is investigated, there may be something from it that would be suitable for a rebuttal case. But at this juncture, as I've told Mr. Baez, that would be no. The court may not know. We continue to get phone call after email from concerned citizens, as I'm sure they do. We have to cull through that information to determine what are just fashion suggestions or prosecution suggestions and what is actual fact or Brady material. And we have been doing that on a regular basis. This was one of those items that was investigated. If it turns out to be something relevant at this juncture, I would say no. But it could before the end of the case.
Okay, as to items 1 through 6, Mr. Baez, any additional comments?
On those items, no.
Okay.
But I do have numerous comments on 7.
Okay, let me finish 1 through 6. The court will find that this is not a discovery violation. The court will specifically find that under Rule 3.220 of the Florida Rules of Criminal Procedure, that the state has a continuing duty to disclose information that becomes available to them. And also, under the case of Brady versus Maryland, they also have that duty which they have complied with. Now, let's move to item number 7, Mr. Baez.
Yes, sir. If I understand Ms. Drain-Burdick's position, they gave us a copy of the hard drive, so therefore they gave us, this is a filtered version of that. And I would equate that to giving us 50 phone books and telling us pick out page 700,631. The reports issued by experts in this case, and I guess we're going to get back to your order again, issued certain opinions, laid out certain dates, laid out issues that may or may show up or may not. As it relates to this date, the only thing that was issued by an expert witness was Sandra Kahn's testimony or report that states the hours of inactivity for the times of the computer search, computer activity on that day. Not who was on, not who may or may not have been on the computer, who may or may not have been home, and what exactly, what pages came up, and so on and so forth. There's so much data that we could be referring to that it now appears that the state of Florida has decided to focus in on or use some evidence during their rebuttal case for which they had before the trial even started. In addition to that, there's no way, when we retain someone to verify the work of the prosecution in this case. So if they're going in a different direction and they issued other reports, especially given Your Honor's admonition and order, that's the area that we asked them to focus on, of course. And after determining that we would not be in need of a computer expert, we withdrew them from the witness list. So here we are without an expert witness on our case. They have had this information.
Just a second. Okay.
They've had this information for almost 3 years, and Ms. Drain Burdick's response is, we've had a copy of the hard drive, so therefore we've had the information. And that's not quite accurate, given the circumstances of how much data a computer contains.
I know you haven't had an opportunity to review it, but Ms. Burdick, what's on this disk for 61608?
Contains all of the computer activity on the desktop.
From what I could see, it's scribbly data. Some of them have photos.
Items created and accessed on the HP, the desktop, on June 16th of 2008. Data that was available on the hard drive if they chose to filter it out themselves. Okay. Mr. Baez's opening statement focused on activity occurring in the morning hours of June 16th. The computer activity, as well as instant messages that were also sent in discovery years ago, negate that timeline.
Well, let me just simply ask this. Was information provided to the defense by the state of Florida on the computer activities on June 16th, 2008?
No, sir.
So you didn't get the hard drive?
We got the hard drive, but that's everything, Judge.
Well, but they gave you all of the information, correct?
They gave us a copy of the hard drive, which contains billions of pieces of data, and they issued reports of what opinions their experts were going to render and what information they had.
Well, let me ask you this, and
if I may clarify something else, Judge, and as it relates to my opening statement, I specifically said the exact hour is unknown. So for the state to allege that this is information that would directly rebut that, again,
it would seem to me, as an outsider looking in, that June 16, 2008 was the last time that the victim in this case was viewed by her grandparents. It became quite evident, even though it is not evidence, that from the opening statement of the defense that the 16th was a day of great importance, and that a so-called timeline of activities dealing with Cindy Anthony as to how she spent her day on the 16th, Lee Anthony as to how he spent his day on the 16th, George Anthony on how he spent his day on the 16th, and last but not least, how Casey Anthony spent her day on the 16th, and whether or not what, if any, activities took place on the 16th of June, on the 15th of June, and on the 17th of June, both on 24-hour cycles, would have been at least of a minimum requirement of review. And I take it at some point you did have a computer expert, I guess, regurgitate whatever was on that computer on some of those days.
Yes, sir.
And if my memory serves me correctly, didn't the state's expert talk about various entries on the 16th when his testimony? He testified to certain events, didn't he?
He did not.
No, he did some event searches for chloroform and other things on other dates.
Correct.
But all of that information came off the hard drive?
It did.
Well, if the hard drive was provided to you, then it was left up to you to decide whether or not what searches you wanted to do on that hard drive, and it was not denied access to the defense, and it was up to you to determine what days you chose to look at and what days you chose not to look at. And I'm trying to wonder, how could it be the fault of the state of Florida that you chose not to look at any particular date when you were given the entire hard drive, and you all knew what dates had some relevancy to this particular case?
I can tell you that we took your order to mean that all opinions that experts intend on rendering must be in a written report, and the basis for that opinion, all of this must be turned over to the defense.
Well, tell me what someone out of the state of the defense enlighten me as to what is the expert going to tell us other than extract, because most folks are not computer savvy. Some people are, some people are not, that can go in and tell us. All they're going to do is bring it up on the screen as to what activity occurred on that particular date. Generally, computer experts, when you want to render opinions, basically render opinions about whether or not somebody has tried to hide something or somebody has tried to doctor something. And, you know, that's what they generally do. But
can I add another point, Your Honor?
Yes, sir. Remember, y'all take as much time as you want to, because we're going to start back at 1:30.
Yes, sir. The issue here, as well, as we're giving computer information after the state has rested. We have withdrawn our computer experts from the witness list because we expected them to testify to what was in their reports and not to new evidence that was now given to us. So if the court's even considering this, allowing them to testify, we would certainly ask to have our experts, given the opportunity for our experts to review this material and see if at all it's...
They can look at it, but
and
it's not new evidence. I don't know how something can be new evidence when it was given to you. Now, what you choose to do with it after you get it is your business, but it's not new evidence.
Well, I disagree, but we can argue that issue at a later time, Judge.
Okay.
I would like more time to review the material, give it to our experts, and then
You're free to do that.
See if we have further points to make.
Okay. Anything else y'all would like to discuss?
Nothing further.
Okay, see you at 1:30.